Their house burned on a Tuesday.
Their policy listed fire as a covered peril. The claim payment, 0. The denial cited a vacancy restriction deep in the contract. In this dramatized composite, the policy's own definition and a file of dated evidence changed the result to a $138,000 payment after the deductible. Rachel and Tom Miller bought a neglected 1950s fixer-upper, their first home. They insured it when they closed and started a major renovation. For several weeks, they slept with relatives while the walls were open, but the property was not abandoned. Their boxed furniture, new appliances, tools, and building materials stayed inside. Tom visited the site repeatedly, and the contractor worked there during the week. 9 weeks into the project, an electrical fault started a fire behind the kitchen wall. No one was hurt. The fire marshal classified the cause as accidental. Rachel reported the loss from the sidewalk. The first call sounded routine. Then came photographs, contractor records, and weeks of questions. The final letter denied the property claim under a provision applying after the dwelling had been vacant for more than 60 consecutive days. Estimated damage was about $140,000. The proposed payment was 0. Fire itself was not disputed. The fight was about whether a house under active renovation, containing the owner's property and receiving regular visits, met this particular policy's definition of vacant. Vacancy and unoccupancy restrictions vary by policy form, endorsement, state law, and type of loss. Some policies use 60 days, others use different periods or language. Do not rely on a generic internet definition. Find the exact provision in your own contract, then check whether the policy separately defines vacant, unoccupied, residence premises, or occupancy. In this composite policy, the definition focused on whether the building contained enough furniture or personal property for habitation. If a key word is undefined or disputed, interpretation becomes state-specific. That is when a regulator, licensed professional, or attorney may be useful. Rachel called her brother Sam. His first question was not, "Was somebody sleeping there?" It was, "What does the policy actually require?" The definition read, "Vacant means containing insufficient furniture or personal property to support habitation." That wording did not automatically prove coverage, but it changed the factual question. The issue was no longer a calendar alone. It was what remained in the house, how the property was being used, and what evidence could verify those facts. The Millers documented the property room by room. Dated photographs showed boxed furniture, a new kitchen still wrapped for installation, appliances, tools, and roughly $30,000 in materials. Contractor invoices and permits showed active work. Tom's calendar recorded 11 site visits in 9 weeks, matched to hardware store receipts and time-stamped photographs. They added utility records, alarm activity, and messages scheduling trades. None of those facts guaranteed coverage. Together, however, they answered the policy's stated concern with evidence rather than memory. A claim file is strongest when another person can verify what happened, when it happened, and why it matters. The appeal stayed now. Exhibit A quoted the vacancy provision and definition in full. Exhibit B contained the dated interior photographs. Exhibit C organized the visit log, receipts, permits, and contractor records. Exhibit D attached the fire marshal's accidental cause finding. The letter did not claim that renovation always defeats a vacancy restriction. That would be too broad. Courts and regulators can reach different results because wording and facts differ. Instead, the Millers asked the insurer to identify which documented facts it rejected, explain how the definition applied, and reconsider the denial under the language actually purchased. The final package used a one-page index, numbered exhibits, and a short timeline. Every assertion pointed to a document. The Millers requested a written response and noted the appeal deadline shown in the denial letter. They uploaded the file through the insurer's portal and kept the confirmation. A paper copy went by trackable mail. There were no accusations and no magic phrase, only a specific coverage question, a complete record, and a request for the next contractual review step if the denial remained. The better time to solve a vacancy problem is before the house becomes unoccupied. Tell the insurer or broker in writing how long the project may last, whether anyone will sleep there, what property will remain, and whether structural work is planned. Ask what coverage is required during that period. Depending on the project and market, the answer could involve an endorsement, a different dwelling policy, vacant property coverage, or builder's risk coverage for the structure and construction materials. Builder's risk does not automatically replace every liability, contents, theft, or living expense protection. Availability, price, and terms vary. Obtain the actual form, keep the confirmation, and calendar any expiration or renewal date. The state insurance department remained a backup, not a guaranteed path to payment. A department can request the insurer's response and review compliance with policy language and state claim handling rules. It generally does not rewrite the contract or automatically choose the homeowner's number. A useful complaint includes the policy, denial letter, timeline, appeal, supporting exhibits, and insurer responses. Depending on the amount and complexity, a homeowner may also consider a properly licensed public adjuster or an attorney familiar with first-party property claims. Check state licensing and deadlines before hiring anyone. In this composite story, the insurer withdrew the denial 17 days after receiving the organized appeal. The covered structural payment was $138,000 after the deductible. The reversal did not prove that every renovated house is occupied. It showed that this denial could not be sustained against this policy definition and this documented record. 8 months later, the Millers returned to the rebuilt house with a much better understanding of what covered actually requires. If a home may sit unoccupied, follow this sequence. Read the vacancy and unoccupancy language before leaving. Notify the insurer or broker in writing. Ask which policy or endorsement fits the renovation. Document property, visits, utilities, contractors, and materials. If a denial arrives, compare it with the exact definition and appeal before the stated deadline. If the process still appears wrong, send a factual file to the correct State Department or qualified professional. Next, on claim denied, her surgery was authorized in writing, but the patient bill said $74,000. Subscribe, because the fine print does not explain itself.